What if your invention, your product, or your method is hiding the catastrophic secret that part of it infringes on someone else's patent rights? No matter how much work, innovation, and coffee you've poured into creating something you're sure is going to be valuable, there's no guarantee someone else didn't have a similar genius idea and take steps to protect it through a patent. If they have, or if they even protect part of what your invention consists of, what you thought was your own idea could cause you extreme pain. Imagine debuting your revolutionary product only to be met not with applause, but with a cease-and-desist letter demanding that you stop production, recall your inventory, and pay significant damages. That's the monster waiting in the shadows, the risk of patent infringement. Wouldn't it be better to take steps to find out if this is a potential problem before you spend a great deal of time and money on development, production, and marketing? The good news is that you can take those steps early on, and you can even take them if your product is already on the market. As a rock and horror-loving patent attorney, I know the best way to deal with a monster is to see it coming. That's where the freedom to operate search and opinion comes in. I'm just going to abbreviate all of that to FTO search for ease. An FTO search is your professional flashlight, meticulously scanning the landscape of active patents to ensure your product can be legally manufactured, marketed, and sold before you invest heavily. It's not about protection, it's about permission. If you're developing a new product, this is the non-negotiable step that saves you from becoming the next legal horror story. How does a freedom to operate search ward off the patent infringement monster? And what are the risks of skipping one? A freedom to operate search is a focused investigation into all the active, unexpired patents in the countries where you plan to manufacture and sell. For example, if you're only going to manufacture and sell in the U.S., you'd only need to look in the U.S. for patents. You look for the patents that could be potentially infringed by your new product or process. An FTO search is not the same as a patentability search. A patentability search asks, can I get a patent for my idea? An FTO search asks, does someone else already have a patent that I might infringe? The cost of an FTO search, which can range from $10,000 to $50,000 or more, is a necessary investment. Why is it so expensive? The search alone takes a significant amount of time and must be done with precision. Then the analysis and opinion take even more time. The entire filing history of any patents of concern should be looked at to determine whether infringement would exist, and the claims must be read and evaluated with an eagle eye. Yes, the price can be steep, but compare that cost to the potential fallout of not having an FTO search done. The immediate scare is a lawsuit. Being sued for infringement means injunctions, stopping sales, product recalls, legal fees, and damages. An FTO search can't guarantee you won't be sued, but it can reduce the likelihood of being sued, and it can reduce the penalties if you are sued and lose. The triple threat is if you lose the lawsuit. If the infringement is deemed willful, meaning you knew the patent existed and proceeded anyway, damages can be tripled by the court. An FTO search, followed by a formal written opinion of counsel from an experienced patent attorney, is the single strongest piece of evidence you can use to show a court that you did not willfully infringe. It demonstrates you acted responsibly and in good faith. Let's look at your monster hunting gear by delving into the anatomy of a freedom to operate search. The entire freedom to operate analysis hinges on the claims section of a patent. The claims define the legal boundary of the inventor's protection. They're the spells that legally protect the invention. Infringement occurs only if your product or method, whatever your invention is, incorporates every single element or an equivalent element of an independent claim. Here's how we search. We look for patents that are technically relevant to your product's function, structure, and operations in the country in which you intend to use or sell your invention. This is a complex, nuanced search that goes far beyond simple keywords. The attorney then looks at the entire filing history of any patents of concern, which is often crucial for interpreting the final claims. Why do you need a lawyer to do the search and analysis? A non-lawyer can find similar patents, but an experienced patent attorney can provide a legal opinion on whether the claims are actually infringed by your product. What happens if a patent freedom to operate search finds potential infringement? If the freedom to operate search reveals a concerning patent your invention may be in danger of infringing, the situation is not hopeless. This is where the magic of design around comes in. We point out the potential infringement and discuss with you how intentionally modifying your product to omit or change at least one element of the independent claim that may be infringed can avoid infringement while achieving the desired result. Here's a quick example. If a patent protects a three-wheeled wagon with a red handle, you can create a non-infringing four-wheeled wagon with a blue handle. You achieve the same goal, a pull wagon, but legally sidestep the patent infringement claims. If infringement is possible, a successful design around strategy creates a better, legally sound product. Now that we've gone over a freedom to operate search, let's now shift a bit to quickly look at other important clearances to get before taking your invention to market. If you have an invention you're launching, looking into patent clearance and protection isn't enough. While a patent freedom to operate search focuses on identifying patents your invention may be infringing, a comprehensive launch strategy for your invention also requires a full spectrum IP checkup, including trademarks and copyrights. A trademark clearance search is similar to the freedom to operate search in that it looks for existing trademarks, your business brand or product name or logo, or other trademarks such as scents and package design are possibly infringing, whether registered or unregistered. Like an FTO search, it provides an opportunity for adjustment to avoid infringement. Copyright clearance involves making sure your related creative works, such as instruction manuals, packaging art, marketing music, and website copy, aren't infringing on others' copyright rights. For example, do you have the proper rights to the photos on your website? The lesson here is don't clear and protect your invention on the patent front only to get sued over what you named it or how you marketed it. Here are the takeaways from this episode. The most important thing to keep in mind is that you should never rely on the assumption that because a product is currently on the market, it's safe to copy or that no patent exists. Before you spend thousands on tooling, manufacturing, and marketing, invest in an insurance policy that matters, a professional freedom to operate search. Be prepared to spend a significant amount of money on the freedom to operate search and analysis opinion, though. Average costs may seem steep, typically ranging from $10,000 to $50,000 or more, but compare that to the costs that could come if you don't have one done. Ready to kill the legal monsters before they get a chance to grow? Let's talk about the specific IP needs for your next big product launch. Intellectual property is one of the most terrifyingly useful tools you have. If you're a creator or other entrepreneur ready to build a frighteningly powerful brand and business, you need to know how to use it. But you don't have to face the darkness alone. To learn more about protecting your creations, your name, your business, and your legacy, you can book a consultation with me at kingpatentlaw.com. I'm Julie King, a licensed attorney in Champaign-Urbana, Illinois, and I help entrepreneurs across the U.S. make smart, legally sound decisions about their intellectual property. If this episode helped you survive the horror of learning about how to protect and manage your intellectual property and business, please like and subscribe if you haven't already. You can find all of my other frighteningly good content on the King Patent Law website, at Spellbinding IP, Patent, Trademark, and Business Strategy on all major podcast platforms, and at King Patent Law on most social media except X. I don't go on that site anymore, and I'm sure you can guess why. The information provided in this episode is for educational purposes only and does not constitute legal advice or form an attorney-client relationship. You should not act on any information presented here or anywhere else on the internet without first seeking the counsel of a licensed attorney, perhaps me, for your specific legal needs. Thank you for tuning in. Stay legally sharp and keep rocking your IP.